Welcome to the Courtroom Club. As Jonker Vorster Attorneys, we spend a lot of time helping clients navigate lease agreements. They're really the bedrock, aren't they?
Absolutely. They set out all the rights, the responsibilities for landlords, for tenants. Super important.
But life happens, things come up, and sometimes a landlord finds themselves needing to, well, end that agreement early.
Exactly. And that's what we're focusing on today.
We're going to do a deep dive into this, drawing on our firm's experience here at Jonker Vorster. We want to give you a really clear picture of when, and maybe more importantly, how a landlord can legally cancel a lease in South Africa.
It's tricky territory. A good lease provides security, but situations change.
Right. What if the tenant isn't, fulfilling their side? That's the core question.
hmm Our goal here is to equip you, the listener, with that practical knowledge. What are the legitimate reasons? What are the correct legal steps?
Okay, let's kick off with maybe the most common reason landlords think about cancellation. That's when a tenant breaches the lease terms, right?
That's the big one, yes. Think of the lease as the rule book. If a tenant breaks those rules, well, that can be grounds for the landlord to act.
So what sort of rule breaking are we actually talking about? What do we see most often?
Well, number one, probably non-payment of rent. And it's usually not just one slip up. We're talking about a pattern, consistently failing to pay on time.
Okay, rent arrears. Makes sense. What else?
Then there are, unfortunately, cases of illegal activities happening on the property. It's obviously a very serious violation.
Serious consequences there, I imagine.
Definitely. Another frequent one is unauthorized subletting. The tenant rents out the place or part of it to someone else without getting the landlord's permission first.
Ah, yeah, that can cause all sorts of issues about responsibility.
Exactly. And property damage is another.
Yeah.
We're not talking about normal wear and tear here, but significant damage. Things that really affect the property's value or usability.
Right, beyond the expected scuffs and marks.
Precisely. And finally, particularly in places like apartment blocks, sexual title schemes. Persistently breaking the body corporate rules. Those rules are there for everyone, so if a tenant constantly ignores them, that can also be grounds for the landlord to look at termination.
Interesting. So it's quite a range of potential breaches, but sometimes isn't there something in the lease itself about ending early?
Yes, exactly. That's a really important point. Many well-drafted leases will include an early termination clause.
Okay, so what does that usually look like?
It basically sets out specific conditions agreed upon up front, under which either party can end the lease before its natural end date.
And the details matter there, I assume.
Critically, the clause must, absolutely must, specify the notice period required, how much warning is needed, and it might also detail any financial penalties, costs involved if it's ended early. Clarity there can prevent so many problems later.
That makes sense. Now, connecting this to the wider legal picture,
Well,
what about the Consumer Protection Act, the CPA? Does that come into play with leases?
it certainly does, especially for fixed-term leases that are longer than 6 months. The CPA has a significant impact there.
How so? What does it require?
Well, a key thing under the CPA is that if a tenant breaches one of these longer leases, say over 6 months, the landlord can't just cancel immediately.
Okay.
The law says the landlord must give the tenant written notice. And specifically, it's a 20 business day notice period for the tenant to fix the breach.
20 business days, so a chance to rectify things.
Exactly. It gives the tenant a clear window to, say, pay the overdue rent or stop whatever action is causing the breach.
So even if it's clear a rent hasn't been paid, you still generally need to give that 20 business day chance for them to catch up before you can cancel.
Typically, yes, for leases falling under the CPA scope.
Do people get confused about that CPA requirement? What are the common trip-ups you see?
Oh, definitely. One common point of confusion is the business day part. People forget that weekends and public holidays don't count.
Ah, so 20 business days could be nearly a month in calendar time.
It can stretch out, yes. Another thing is the notice itself. It can't just be vague. You have to clearly state what the breach is and what the tenant needs to do to fix it within those 20 days. If the notice isn't detailed enough, the whole cancellation could be deemed unlawful later on.
Right, precision is key. Okay, another scenario clients often ask us about. What if the landlord sells the property while there's still a tenant with a lease?
Ah, yes, the classic Huurgat voorkoop situation.
Which means?
It's an old Dutch legal phrase, basically meaning lease goes before sale. Generally, this protects the tenant.
How does it protect them?
It means if the property is sold, the existing lease usually stays in place. The new owner buys the property with the tenant and the lease. They essentially become the new landlord, inheriting the agreement.
Okay, so the lease survives the sale normally.
Normally, but, and this is a big but, if the original lease agreement doesn't specifically include a Udgavorkup clause
Hmm.
or words to that effect,
Then what?
then the situation might be different. Without that protection explicitly in the lease, the landlord might be able to terminate the lease when selling, provided, of course, they give the correct notice outlined in a lease or required by law.
So again, it highlights how important the wording in that initial lease is.
Absolutely critical.
What about a situation where the tenant just disappears, leaves the property without saying anything? Abandonment.
Yes, that does happen sometimes. The
Yeah.
landlord shows up, maybe for rent or an inspection, and the place is empty. No word from the tenant.
What can the landlord do then? They can't just leave it empty forever, losing rent.
No, exactly. If a tenant genuinely abandons the property without notice, the landlord can generally consider the lease canceled because of the tenant's actions. They can then take legal steps to formally reclaim possession.
But there's a process, right? You can't just assume abandonment.
Correct. There's usually a process to follow to confirm it legally before just changing locks, for instance.
Okay, so we've covered the main reasons why a landlord might cancel. Now, let's get into the how. What are the actual steps? It's definitely not just telling them to get out, is it?
Absolutely not. That's a recipe for disaster legally. South African law is very clear. There are specific procedures. You skip them at your peril.
So, step one, what's the absolute first thing?
Formal, written, notice. That's the starting point. You must provide the tenant with a formal written notice saying you intend to cancel the lease.
And this isn't just a quick email, presumably. What needs to be in this notice?
No, it needs to be legally sound. It must clearly state the reason for termination. If it's a breach, specify the breach. Which clause? What happened? Be specific.
Like rent for July and August is outstanding.
Precisely. Or unauthorized occupant, Mr. Smith, residing since June 1st.
Yeah.
And crucially, if the CPA applies, remember that 20 business day rule, the notice must state that period clearly, giving the tenant the chance to rectify. And it also needs to spell out the consequences. What happens if they don't fix the breach or move out? Clarity is vital. No room for misunderstanding.
Okay, so specific reasons. Reference the lease, mention the rectification period if needed under the CPA, and state the consequences. Got it. What if the tenant gets this notice and does nothing? Ignores it, doesn't fix the breach, doesn't leave.
Right, this is where the next potential step comes in. It's not always mandatory, but often advisable. The Rental Housing Tribunal.
The tribunal, what's its role?
It's basically a specialist body set up to handle disputes between landlords and tenants. It can act as a mediator.
So trying to find a solution without going straight to court.
Exactly. It's often quicker, less formal, and much cheaper than court action. And importantly, the tribunal can make binding rulings. So a resolution there can be legally enforceable. We often suggest clients consider this route.
A good alternative, potentially. But what if mediation fails or the landlord decides court is necessary? What's the next legal move?
Then the landlord needs to apply for a formal eviction order. This is done through the courts, either the magistrate's court or the high court, depending on the case specifics.
And that involves?
It means preparing and filing a proper legal application. You need to include all the evidence, the lease, the notice you sent, proof of the breach. And critically, the tenant must be formally served with notice of these court proceedings.
So they know it's happening and can respond.
Yes, they have the right to oppose the application and present their case to the judge. Then there'll be a court hearing where the judge looks at everything from both sides and decides if the eviction is lawful and justified.
Okay. And if the judge agrees with the landlord and grants the eviction order, is that it? Tenant has to leave immediately.
Not usually immediately. The court order will typically specify a date by which the tenant must vacate. The court sets what it considers a reasonable period, looking at the case circumstances, maybe considering the tenant's situation.
Right. So there's a deadline set by the court.
Yes. And if the tenant still doesn't leave by that court-ordered date, then the landlord can get the sheriff of the court involved.
The sheriff.
Yes, the sheriff is the official who is legally empowered to enforce the court order. If necessary, they can physically remove the tenant and their belongings from the property.
Okay, so that's the enforcement mechanism. Once the tenant is out, legally evicted, what can the landlord do then?
First things first, secure the property, change the locks, make sure it's safe.
Makes sense.
The landlord can also still pursue the tenant for any money owed outstanding rent, costs from the eviction through separate legal action if needed.
Right, the debt doesn't just disappear.
No. And then finally, the landlord can get the property cleaned up, repaired if necessary, and ready to rent out again to someone new.
It really sounds like a very structured, step-by-step legal process. You mentioned skipping steps is risky. What exactly are the consequences if a landlord gets it wrong? Tries a shortcut, maybe changes the locks too early?
Oh, the consequences can be severe. If a landlord acts unlawfully, say, an illegal eviction, the tenant has rights. They can go to the rental housing tribunal or court.
And what could happen to the landlord?
The landlord could be ordered to pay financial compensation to the tenant, sometimes significant amounts for damages, inconvenience, maybe even alternative accommodation costs.
Wow. Okay, so it could backfire financially.
Hugely. Plus, illegal actions lead to delays. Legal battles drag things out, meaning more lost rent. And beyond the money, it damages the landlord's reputation, makes it harder to find good tenants next time.
So the clear message, the takeaway from us at Jonker Vorster Attorneys is always get legal advice before you act.
Absolutely. 100%. Don't try to navigate this alone. The law is complex. The procedures are specific. Getting expert guidance from the start protects you from those legal and financial pitfalls.
That's why we're here after all, to provide that guidance.
Precisely.
Okay, so to wrap up our deep dive today, we've looked at the legal grounds for a landlord canceling a lease in South Africa. Things like tenant breaches, specific clauses in the lease, the CPA's role, what happens when selling the property, and tenant abandonment.
hmm And we've walked through the essential steps for a lawful cancellation, that vital written notice, the option of the rental housing tribunal, applying for a court eviction order, and finally, regaining possession legally.
And we've stressed how important it is to follow these steps correctly to avoid serious negative consequences.
Couldn't emphasize that enough. Operating within the law is paramount.
So if you are a landlord listening to this and you're facing a situation where you might need to cancel a lease or consider eviction, please do reach out to us at Jonker Vorster Attorneys.
Yes, our team has deep expertise in property law, and we can guide you through the process correctly and effectively.
Definitely seek that advice. And just to leave you with something to think about, considering all these complexities we've discussed, what proactive steps could landlords take right at the beginning when drafting or signing a lease to try and minimize the chances of disputes and maybe avoid needing to cancel down the line altogether?
That's a great question for landlords to ponder. Prevention is often better than cure, as they say.